what does SB9 do? It allows urban lot splits as a matter of right, meaning you're able to split up a lot without any discretionary entitlement or approval. It also goes beyond that. It allows duplexes as a matter of right in single family zones. And no public hearings are allowed under SB9, period. None. I mean, the legislation is very explicit about the fact that no public hearings can be authorized. And it also says that only objective zoning standards can be applied. And contrast that with subjective zoning standards. And if you go and you look through the Hillside ordinance and the baseline Hillside ordinance and the myriad of other existing zoning regulations that we have, you will come to the conclusion that many are subjective and not objective. This law preempts all subjective zoning standards. Again, what is an objective zoning standard? There's a definition provided in the law. An objective zoning standard is defined as follows. Objective zoning standards, objective subdivision standards, and objective design review standards mean standards that involve no personal or subjective judgment by a public official and are uniformly verifiable by reference to an external and uniform benchmark or criterion available and knowable by both the development applicant or proponent and the public official prior to submittal. These standards may be embodied in alternative objective land use specifications adopted by a local agency and may include, but are not limited to, housing overlay zones, specific plans, inclusionary zoning ordinances, and density bonus ordinances. Just let me highlight something there. You know, a lot of the projects that we see in our before our neighborhood council are discretionary in nature. In fact, the overwhelming majority of them are discretionary in nature. By its very definition, a discretionary application embodies subjective zoning standards. And if you look at those findings, a lot of times the ZA has to determine that a project is consistent with the public health, safety, and welfare, like really mushy things like that. That is not a objective zoning standard. Now, there's been a lot of conversation in the news media specifically. When this SB9 was passed, there were statements in kind of sloppy journalism, if you ask me, that said that SB9 did not apply in fire-prone areas, period, end of story. Well, it's far more detailed than that. SB9 does not exempt project in very high fire hazard severity zones. This is a perfect example of the devil being in the details. I don't want to necessarily read this whole thing, but I want to highlight the last sentence. It says this subparagraph does not apply to sites excluded from the specified hazard zones by a local agency pursuant to subdivision B of section 51179, or sites that have adopted fire hazard mitigation measures pursuant to existing building standards or state fire mitigation measures applicable to the development. Okay, here's what it did. It said, generally, SB9 doesn't apply to projects in the very high fire hazard severity zone, except when those projects have adopted fire hazard mitigation measures pursuant to existing building standards. Our city has had those for years. They have fire hazard mitigation measures. It's like brush clearance, it's sprinklers, it's making sure that you have the right roofing material. You'll notice in the motion I put together that we need to get more clarity about exactly what fire hazard mitigation measures the city has adopted. And maybe we need to modify them. But this was inaccurate journalism when it said that SB9 excluded projects in the very high fire hazard severity zone. Two questions. Let's see here. What are the city's adopted fire hazard mitigation measures? I already
Here's what I found.
I already asked that. And also, what are the state fire mitigation measures applicable to development? I want to go back to the previous screen. Look out that last sentence. It says, that have adopted fire hazard mitigation measures pursuant to existing building standards or state fire mitigation measures applicable to the development. So one of my questions is, what are state fire mitigation measures applicable to the development? And it also says or, not and. So it appears a project could comply with local fire hazard mitigation measures and not with the state fire mitigation measures and still be eligible for an SB9 project. And again, that's another thing I mentioned in this slide here. Development only has to be compliant with one of those things, not both. And the reason why that matters is that as of July 1st, 2021, there are new minimum fire safe road regulations adopted by the Board of Forestry that apply the 20-foot roadway requirement in the very high fire hazard severity zones within the city of Los Angeles. So I was hopeful that that would be some sort of saving grace for us, but it appears that the word or as opposed to and may not allow that. Another key exception, this one I am excited about, and the journalist who wrote the many articles about SB9 did get this right. You'll notice some of the articles talk about SB9 not applying to, quote, environmentally sensitive areas. Well, that's a synopsis of this paragraph. SB9 excludes development located on a site that is, quote, habitat for protected species identified as candidate, sensitive, or species of special status by state or federal agencies, fully protected species, or species protected by the Federal Endangered Species Act of 1973, the California Endangered Species Act of Division 3 of the Fish and Game Code, or the Native Plant Protection Act. So I'm going to work us through that because those are a lot of different things, actually. So let's talk about that. You have to carefully parse through what that includes. It includes species identified as candidate for protection by state or local, state or federal agencies. So there's the candidate species, and we'll talk about one of those in a second. It also includes species identified as sensitive by state or federal agencies. It also covers species identified as special status by state or federal agencies. It also includes fully protected species, and then just species protected by the Federal Endangered Species Act or the California Endangered Species Act. So that's 5 different types of species or plant types that that this covers. So do we have any candidate species that that you know, in the Santa Monica Mountain Zone within our neighborhood council area that parcels might provide habitat for? And the answer absolutely is yes. So what you'll see here on the screen is a picture of a mountain lion and the Santa Monica Mountains here in Laurel Canyon. It's an uncollared mountain lion at the Let's Buy a Mountain property. And the California Department of Fish and Wildlife named this local population of mountain lion. I'm not being super precise exactly in how I think they call it an evolutionary significant unit, but let's just boil it down just a little bit. They named this local population of mountain lion a candidate species for protection in April of 2020. And under the Fish and Game Code, candidate species are protected under the Endangered Species Act. And it's my contention that any development of raw land in the Santa Monica Mountains that is adjacent or close to other areas of large open space would clearly provide habitat for the mountain lion. And the reason how I get to that conclusion, and I'm not a biologist, but I think this makes sense based on the documents that I've read, is that deer, mule deer, are often seen on these parcels. And the most common prey for the mountain lion is the deer. So if deer use a project site to eat or drink, then that parcel also provides habitat for the mountain lion. So in sum, if you see deer on a parcel, I think one can reasonably conclude that that parcel provides habitat for this candidate species. And because it does, that parcel is not eligible for an SB9 project. Now, moving on to that next grouping of animals and or plants that are in that exception. Those are the sensitive species. And CDFW has prepared a list of sensitive natural communities. And CDFW states that all natural communities on this list with ranks of 1 to 3 are considered sensitive. Notably, California black walnut woodlands are on this list. And we have lots of California oak walnut woodlands. So we have lots of these woodlands in the Santa Monica Mountains. And so I think that we have some protection there as well, because arguably an SB9 project shouldn't be allowed to go forward if these woodland types, which are designated sensitive species, are located on the parcel. Special status plants, you'll see here is on the right hand. I often have that as my background on these Zooms. It's a beautiful walnut tree in bloom from 2 years ago, right after the pandemic started. And the California black walnut is deemed a special status species. Additional thoughts. Government Code Section 65913.4J talks about a parcel having habitat for a project talks about a parcel providing habitat for such species. It doesn't say that the project will not have a significant impact on the species or that mitigation will suffice to reduce the impact. So a lot of times when we're talking about CEQA, we're talking about whether or not a project will have a significant effect on the environment. And that means more than an infinitesimal impact. That's not what we see in SB9. The question is whether or not the project site provides habitat. It doesn't talk about how much habitat, just whether or not any habitat is provided for these species. But the big question, and we'll talk about later when we're debating the motion, and maybe during the Q&A question, is how is the planning department going to figure out, or LADBS even, whether or not a project has habitat value for these protected species? If a random person just goes down to the planning counter, how is this person going to know this? And so that sort of begs the question, should the city require, for example, a tree report to see whether or not these woodlands or specific tree species exist on that site? Should they require a biological resource assessment report at application? So these are some of the things that we need to think about. I'm going to kind of quickly go through some other big points here. SB9 requires the city to require the applicant to sign an affidavit stating that the applicant intends to occupy one of the housing units as their principal residence for a minimum of 3 years from the date of the approval of the urban lot split. Of course, this could be abused. We all know that, but hopefully it will prevent developers from buying up an older house, dividing the lot, building 2 duplexes, and then moving on. They would have to live in one of those housing units under the law. Again, devil's in the details. We need to figure out a mechanism to make sure that that actually is enforced. Parking. A lot of people in my neighborhood have brought this issue up. The city can still require 1 off-site parking space per housing unit. This is a significant reduction from what is currently required. 2 off-site parking spaces per housing unit. Um, There is an exception if a project is located 1/2 mile walking distance of either a high quality transit corridor as defined in subdivision B of section 21155 of the Public Resources Code, or a major transit stop as defined in section 21064.3 of the Public Resources Code. So many communities are not, especially in our neighborhood, within a 1/2 mile of a high quality transit corridor or a major transit stop. And I have some details here about how these things are measured. Major transit stops include subway stations. Um, but I think the biggest takeaway here is that maybe like along the fringes of our neighborhood council boundaries, there might be projects that would be completely exempted from the parking requirement, like maybe at like the very base of Laurel Canyon Boulevard or something, or the very bottom of like the Dahini Sunset Plaza neighborhood area. But the majority of them are not going to be within a 1/2 mile of these, areas. But the law does cut our existing parking requirement in half. That's what it is. It just cut it in half. So that is what it is, and I have no solution for that. In some, the city can still require 1 parking space per housing unit, but not 2. So street parking is going to get harder to find. Minimum lot size. For an urban lot split, SB9 does not require the city to approve lot splits that would create lots of less than 1,200 square feet. Most of the lots in Hillside communities would meet the size definition for a lot split. So basically, if you had maybe like a lot that was, 2,100 square feet, then you couldn't do a lot split. But it's almost not even worth talking about because there's so few lots that are that small to begin with. Tenant issues. If a property has been occupied by a tenant in the last 3 years, then it's ineligible under SB9 to build a duplex. So that's a significant safeguard for renters. One has to wonder about people that are, how this is going to get enforced. It's not like the city has a registry of, renters, and you could just pay off the person and or whatever. So that's a big unknown here. Demolition limits. SB9 limits any demolition of more than 25% of the existing exterior structural walls. However, there is an exception, and it's really important for us to think about. The law goes on to state that more demolition may occur, quote, if a local ordinance so allows. We need to ask the city what is allowed under the Los Angeles Municipal Code. I believe we have a 50% rule, but we need to confirm this. And there's nothing that says we can't change our law. ADUs and junior ADUs. In the lead up to the passage of this bill, there were a lot of graphics that were sent out kind of outlining what an absolute worst case scenario could be in terms of the number of housing units that could be created. But I want to highlight one thing here. If an applicant uses both the urban lot split and duplex provisions of SB9, then a local agency shall not be required to permit an accessory dwelling unit or a junior accessory dwelling unit on the newly created parcels. So that was a bit of a give in response to the criticism to the law. But it doesn't say that. It says that the city shall not be required, not that they couldn't allow it. Public notice and appeals. I suspect the city is going to do administrative reviews for these projects. The city is calling them project compliance reviews, and they issue letters of compliance. There is a law that's over 10 years old that has a lot of similarity with SB9, believe it or not. It deals with affordable housing. And it also has that division between objective zoning standards and subjective zoning standards. And I've taken a look at one of their quote project compliance reviews for that project. And the planner weirdly was tasked with this. I guess his task was to literally go through all of the existing regulations that would otherwise be applicable and parse out all the subjective ones and apply all the objective ones. And you know, there's even subjectivity in deciding what is an objective and subjective. I mean, that also gets dicey. We need to get confirmation of the process for the approval for SB9 projects that the city intends to use. And I really believe that there should be some type of public notice so that interested parties can file appeals, including perhaps CEQA appeals, if they believe the city got it wrong. And the parcel does, for example, provide habitat for protected species. I have almost no faith that a person at the counter is going to be able to ascertain whether or not that particular parcel is eligible for SB9 because it provides habitat for those protected species. They don't even have the resources at their disposal. They're certainly not driving out to the site to look at it. At most, maybe they're doing a desktop review, like using Google Earth and whatever they can see on Zemus, which is not enough. So I think it's really important that there be some sort of appeal process as a safeguard to ensure that only those projects that are eligible for SB9 are processed. But I want to highlight that the city does have a CEQA appeal ordinance that was adopted a few years ago, and it has a very short window, so only 15 days. And so it's not just that an appeal process needs to be created, also a notice process needs to be created, because if you don't know something's going to happen, then you'll miss the deadline to file an appeal. So you'll notice in this draft motion that I put together, that's one of the things that I think staff should evaluate. This is something that's a little bit disturbing. You see here a grove of oak trees in my neighborhood. And I think it's unclear if the city's protected tree ordinance is an objective zoning standard. The ordinance does not mandate tree replacements, contrary to popular belief. It gives the option of the Board of Public Works or their designee to require such a replacement if they determine that removal is necessary in order to allow for reasonable development. That seems pretty subjective to me. Further, the city takes the position that this is not a zoning regulation at all, but a regulatory compliance measure. So, and I'm a little concerned about this. That begs the question, regulatory compliance measures. The city has a whole host of regulatory compliance measures that even for by right projects, they require. And I'm sure people in our committee have seen these RCMs, as they're called. And some of those RCMs are even subjective. Even though they're called regulatory compliance measures, they imbue discretion in the official, either the local building official or other people to require certain things. And I'm concerned that some of these RCMs may be deemed to be subjective and not objective. Another thing I'm concerned about is the Hillside retaining wall ordinance and whether or not that's an objective zoning standard. I mean, certain aspects of it are, yeah, you can build, when it comes to measuring height, that's objective. When it comes to the number of walls, that's objective. But when you want to go above that, say you want to do 3 walls, or say you want to do 1 wall that's 20 feet, that bumps this into the discretionary world, where a zoning administrator has to determine based on really mushy factors whether or not allowing that would cause harm to the public health, safety, and welfare. So that's subjective in its very nature. So what happens when someone wants to do that? What happens when someone wants to do a 20-foot wall for one of these things? Does that mean the city just has to allow it? So that's a consideration. Also, substandard roadways. I initially thought that the 20-foot roadway requirement in the Hillside ordinance was likely an objective zoning standard because it's measurable, it's definable, there's no subjectivity. And in that part of it, it actually is. But what's not objective is when you're seeking to deviate or seeking a waiver for compliance. Because most of these projects that we have come to us, they're seeking a waiver, they're seeking a ZAD because they believe it would be impractical or infeasible to strictly comply with the code and to improve the roadway all the way to the boundary of the Hillside area. But let's see here.
Jamie, how
Yeah.
much longer do you have? You're at 25 minutes.
Four more, and then I'll be quiet.
No problem.
I thought this was going to be a single meeting. Sorry. But here's what I want to highlight in SB9. It says, notwithstanding section 66411.1, a local agency shall not impose regulations that require dedication of rights of way or the construction of off-site improvements for the parcels being created as a condition of issuing a parcel map for an urban lot split. So they're saying that even if you have an objective zoning standard that requires an off-site improvement, you can't do it. That's what they're saying. And that's a big, honestly, the CPR requirement, the continuous paved roadway requirement, has been one of the saving graces of our neighborhood council for almost 30 years. And protection, and a key protection for our community. The city, but I do want to highlight here, this is very nuanced. That offsite improvement prohibition only applies when you are doing urban lot splits. If you try to only use the duplex provision, they can still require offsite improvements. Very nuanced. The city attorney will need to opine on this, but I have a feeling that the continuous paved roadway requirement may be preempted because it would mandate an offsite improvement in order to comply with the law. And the standards for issuance of a ZAD are definitely not objective zoning standards. Again, I just mentioned them. ZA has to opine or conclude that strict compliance would be impractical or infeasible. That's not objective. There is an escape hatch. SB9 excludes completely and totally, quote, lands identified for conservation in an adopted natural community conservation plan, habitat conservation plans, or other adopted natural resource protection plan. I did a little research regarding natural resource protection plans. I couldn't find any good examples in California. But many communities on the East Coast have them. And these are separate and distinct from natural community conservation plans. So what could we do here? Well, here's an idea. We could develop a natural resource protection plan. Another option would be for the city to deem the draft wildlife corridor ordinance a natural resource protection plan. And look at this purpose statement in the draft ordinance. It says, the overall intent of the ordinance is to achieve protection of natural resources. So I don't think it's a big stretch to say that this draft ordinance constitutes a natural resource protection plan. Another option would be for the Conservancy, the Santa Monica Mountains Conservancy, to adopt a resolution that the Santa Monica Mountains Comprehensive Plan constitutes a natural resource protection plan. Implementation issues, only 2 more slides. SB9 allows cities to draft implementation ordinances. It says, quote, a local agency may adopt an ordinance to implement the provisions of this section. While the city would take forever to do this, it would be useful if we could put some more meat on the bones as to what the city considers to be habitat for sensitive and candidate species and objective zoning standards. I suspect that the Department of City Planning is going to come out with an implementation memo in the interim. And part of the motion that I put forth today is an effort to get us to influence what's going to be in that implementation memo. Now, there has been some discussion about whether or not the city could adopt a moratorium while the implementation ordinance is being drafted, and we might want to ask the city attorney about that as well. And the final safeguard in the ordinance is that the law states that a local agency may deny a proposed housing development project if the building official makes a written finding based upon a preponderance of the evidence that the proposed housing development project would have a specific adverse impact upon public health and safety or the physical environment, and for which there is no feasible method to satisfactorily mitigate or avoid the specific adverse impact. So you have to have a written finding. It has to be based on a preponderance of the evidence. You have to have a specific adverse impact, and there has to be no feasible method to satisfactorily mitigate or avoid the impact. So we'll talk about the motion in a little bit. I hope everyone got it. But I'm going to pause there for a Q&A. So who has their hand up? I thought Kathy had her hand up.
Of course I do. I have a couple of questions. First, so if they have a house plus an ADU, they are required to have 2 spaces because they are separate residences. Is that correct?
I'm not exactly sure what the existing parking requirements are for ADUs, but I know that the law requires one. It says that a city may require 1 parking space per housing unit. So,
Okay.
yeah.
And what is the size of the lot that you said would not be developed? I missed that. I'm sorry.
Can't do an urban lot split if it would create a lot that was less than 1,200 square feet. So basically, any lot that's 2,400 square feet or greater is eligible for SB9. And most, sometimes we have some 2,500 square foot lots in Laurel Canyon, but they would still be eligible.
Right. Okay. And also in your appeal, I haven't read your letter. I haven't, unfortunately. I've been out all day, but does it include within it a wildlife appeal and notice and a tree ordinance objective standard?
I think these motions are a little bit more, I styled this as a motion, not as a letter. If we did it in a letter form, we can maybe go into more detail about what we expect. The motion is, it says that we need to, it directs the Department of City Planning and Building and Safety to develop a protocol for determining how to evaluate and exclude those parcels that provide habitat for protected species. It doesn't tell them how. It just says, we hereby direct you to evaluate how to implement the law consistent with this exception.
So if we start to work on that ordinance that you were talking about, a regulatory compliance measure.
You mean an implementation ordinance?
Thank you. I'm sorry. There's so many terms there. Okay. Yes. If we start to
working on it, but go ahead.
I'm sorry. What?
Not necessarily us. I mean, that would be working on it, but the city would be working on it.
But if we got behind it and got support for it, is there a way for us to really do a push to enact that?
Yes, but I think that before the implementation ordinance, if we were a city like Beverly Hills or Culver City or Santa Monica that was nimble and capable of not moving at snail speed, we could have an ordinance like this adopted in 3 months. But the city of LA is completely and totally incapable of doing that.
True.
So in the interim, there's going to be an implementation memo. I can't guarantee it, but I suspect there's going to be an implementation memo that's going to come out. So I think we should focus our efforts on making sure that that implementation memo has sufficient, has a rubric and has a specific criteria that staff utilize to ensure that those parcels that are not eligible are not processed under SB9. So I think that we should, in this little next few months, really focus on getting on the implementation memo, and then we can work on the implementation ordinance later.
Right. Now my thought here is that if people begin to really act on this new law, that there will be a rush and there will be a lot of mistakes made, which can also lead to a lot of dangerous building practices, which could come to bite LA in the butt and is going to cause a number of lawsuits against it. So potentially this could be a short-lived ordinance or law.
I'm not willing. I hear you, but that's not something I'm willing to accept. So,
I agree with you completely, but I'm stating a thought that I've
totally.
had, in my head. So anyway, thank you
Does
so much.
anybody
It was
else
great,
have any
Jamie.
questions?
There's
about this?
2 attendees that have questions.
Go ahead. We're gonna have to limit them to 3 minutes each.
Okay, one
Okay.
is Jeff Daniels and one is Rick Israel. So I can start with Jeff Daniels.
Can you hear me now?
Yes.
Oh, okay. First of all, thank you so much, Jamie, for this presentation. It was really very informative, and I wish we had all night to talk about this. I don't know if you're open to sharing your contact info, but I would love to follow up with you on it.
Sure.
My question, I have a couple of specific questions. One is, you seem to be saying that the fire hazard rule is not the kind of doesn't disqualify most of the Hillside properties, because any place that has done any kind of mitigation would still be eligible. Did I understand that right?
Yes, and just to reiterate that real quick, there's a loophole. There's an exception to the exception. And projects that have, quote, adopted fire hazard mitigation measures pursuant to existing building standards are eligible. And so our city, so you'll see in the motion that we need to better understand what the, quote, fire hazard mitigation measures that the city has adopted pursuant to existing building standards are. I did some research a few years ago, and it appears that those are not what you think. They're not that big of a issue. I mean, we're talking about sprinklers and, fire alarms and things like that. They're nothing that's going to prohibit someone from building an SB9 project.
Mm-hmm. Okay. And then you mentioned this this issue of the right of way. So does that mean that if a lot split would require, let's say, the front lot to grant a right of way to a rear lot, that would be a prohibition?
Well, it says that you cannot require, what did it say? Looking back through this right here. You cannot require dedications of right of way or the construction of off-site improvements. Shall not impose regulations that require dedications of right of way. So but that is only for urban lot splits. If someone wants to avail themselves of both the urban lot split and the duplex provision, then that one goes away. And if you only avail yourself of the duplex option, that doesn't apply. But if you're only doing an urban lot split, a city cannot require a dedication of any right of way.
You mean it's not allowed to dedicate any right of way?
Not
Or-
that you couldn't, right? You could clearly, but they shall not impose regulations that require it.
So a front and rear lot split would not be allowed. Is that correct?
No, it would be. The person who's splitting can do that. It's just the city can't require
I
any
see.
right of way as
I
part of
see.
a mitigation, basically.
So then my last, I mean, I know I'm out of time, but I don't know who is it within the city that has jurisdiction over the implementation plan?
It's probably going to be both
Vince Bertoni, I would think.
Vince and the head of LADBS. That's why you'll notice that Nuri Martinez, she came, our council president came out the gate and she filed a council file directing staff to analyze certain implementation issues. And that's who she directed her motion to, the head of DCP, Department of City Planning, and the head of the Building and Safety Department.
And the city attorney as well, I think, is going to get
Oh,
involved.
yeah, for certain.
Well, anyway, thank you so much
No
for
problem.
all this information. I really appreciate it.
Okay, next is Rick Israel.
I'm going to limit that to 2 minutes. We're over an hour already. Go ahead. Rick, are you there?
Rick,
Yep, go ahead and unmute. You should be able to.
Yes, I'm here. Can you hear me now?
Yes.
Thank you. And thanks for your presentation. I'm a little confused. I mean, number one is it seems like your focus is on new development versus existing. And I'm curious on if it's an R1 zoning, isn't there minimum lots that still apply to that zoning? Meaning they're not changing if it's a $5,000 square foot minimum. They're not saying that you can change that to 2,500 each, are they?
No, they actually are.
Yeah.
That's exactly right.
Okay.
That's what's so problematic about it.
That's interesting because I have a property in Vista and they still require whatever, I mean, you can still build, but not for the lot split. I mean, you could still build your ADU, you could still build, if it falls within the SB9, you could still build, it's not restricting that. But as far as a lot split, they're not allowing a 2,500 square foot. They're allowing, in that case, their minimum is a 10, my property, it's a 10,000 square foot lot, and I'd have to have 20,000 to do a lot split. I couldn't take that. I couldn't take something that was less than what their minimum is per zoning and divide that. So I'm kind of
Rick,
interested.
your time is up.
If
Let
they
Jamie
have,
answer the question, please.
I don't think that they have started implementing SB9 yet. So that's going to change. That's all I'm going to say. That's all I'll say. Stay tuned.
Okay.
The next
And one
person up is
last
Don
really quick
Lowe's.
thing is, there's access to these back lots is a real issue. If you have a building on the front, it's like you can't get a car back there, or, it's the city
Rick,
going to allow an extra driveway.
Thank
Rick,
you.
we've got to move on.
Okay.
Okay, Don Lowe's. Don, are you there?
Yes, I'm here.
We can barely hear you.
I can hear him. Go ahead.
Okay, go ahead.
Jamie,
Yes.
the significance of LA City as a charter city applying to any of this.
This law applies to both charter cities and general law cities. And, whether or not that's constitutional or will pass legal muster will be decided in the years to come. But right now, unless the city just refuses to adhere to the law, then it's going to get implemented.
Do you know if there's any communication with the city attorney's office with respect to future opposition to this?
I have no idea. Honestly, I don't. I've been really focused on the, honestly, working just kind of a fear, like we have over 1,000 vacant lots in Laurel Canyon, and many of them have could be ripe for the picking. And I just really kind of, been really focused on ensuring that those environmentally sensitive parcels are not developed under SB9, because I just think that obviously this was a compromise bill, a multi-year effort to get this passed with many compromise aspects of it. And I fear our cities just sort of, I hate to be so mean, but just like they're so big and they kind of lazy that that they're not gonna vet these projects very well, and that we're not going to get the benefit of some of the exceptions that were baked into the bill.
Don, do you have anything else to say?
Not at this moment. Thank you, Bob.
Okay, Travis, last person.
Yeah, well, first of all, thank you, Jamie, for putting this together and also for drafting the motion that was posted to the website today. In the interest of moving things along, I would like to move that we adopt the motion that was submitted and circulated. And just to summarize, the major requests are that a request to Department of Planning and Department of Building and Safety analyze the following: evaluation of hillside regulations that are considered to be objective, development of noticing and appeal procedure to contest applicability of projects approved SB9 as an environmental safeguard, whether existing regulations or ordinances adopted by the city constitute a natural resource protection plan, the circumstances in which local building officials may deny a project on the grounds that proposed project will have a specific adverse impact upon which public health and safety or the physical environment for which there's no feasible method to mitigate said impact, and whether the city's existing fire hazard mitigation measures allow for development of SB9 projects, notwithstanding Government Code Section 65913.4. So I'll make that motion.
I second.
I second it.
I third.
Okay,
Purpose of
who
discussion.
seconded it? Andre?
I did, yeah.
Good. All in favor?
Well,
I,
Are there any objections? Are there any abstentions? Unanimously passed.
I also just want to say real quick is that I quickly put that together. It can be tightened up. So like on that kind of following list, in between now and tomorrow, if you come up with better things, then let's make some amendments to it.
Okay, good. Moving